Good afternoon. Welcome to the Shearman and Sterling World Championship round of the 2005 Shearman and Sterling International rounds of the Philip C. Jessup International Law Moot Court Competition. Thanks to all the teams and coaches for an incredible competition so far this week. This is just the capstone to something that started back in early September for all of you. At this time, we're going to go straight to the round. I apologize for the delay. Thank you all for coming. This is going to be a very exciting round. Arguing as applicant is team number 330, Nicholas Luke, Stephen Kolditz, and of counsel Julian Ensby. Also on the team, Ruth Katz and Cameron Forsyth. For respondent, Siti Aliza alias Milati Abdul Hamid, and of counsel Nbun Ka. Also on the team, Fadia Nadwa Fikri and Asma Mohammed Yunus. Our judges today are, as president, Her Excellency Dame Rosalyn Higgins of the International Court of Justice, Professor James Crawford of the University of Cambridge, and James Carter of the law firm of Sullivan and Cromwell, President of the American Society of International Law. In a moment, the bailiff is going to call all rise. We should all rise. The judges will be let in, and the round will begin. Good luck to both teams. This has been a splendid week.
All rise. The International Court of Justice is in session. The distinguished panel consists of President Higgins and the Honorable Judges Crawford and Carter.
Good afternoon. Please be seated.
As you're all well aware at this point, the case before the court is the matter of the Republic of Apollonia versus the Kingdom of Raglan. The applicant and responding teams are each allocated 45 minutes to present their respective pleadings and elections.
We understand that the first speaker for the applicant team will be Mr. Luke. Mr. Luke, you have the floor.
Madam President, Your Excellencies, may it please the Court. My name is Nicholas Luke and I appear on behalf of the applicant in this matter, the Republic of Apollonia. I am assisted by my co-agent, Mr. Stephen Kolditz. Today I shall be speaking for 22 minutes, my co-agent for 20 minutes, and we reserve 3 minutes for rebuttal. Your Excellencies, this case involves Apollonia's peaceful exercise of its maritime freedoms. Freedoms that have been disrupted only, and tragically, by the unlawful and violent acts of Raglan's agent Thomas Good. As such, I will be making 2 primary submissions. The first of those is that Raglan is responsible for the attack upon and wreck of the Maru. The second is that Raglan's scuttling of the vessel was unlawful and that it owes compensation to Apollonia. My co-agent, Mr. Kolditz, will move on to address the Court in relation to Apollonia's alleged liability for the damage to the Norton Shallows. He shall firstly submit that Raglan lacks standing to seek compensation for such damage, and secondly, that in any event, Apollonia has not breached its obligations with respect to the transportation of mulks. If I might turn then to the first of my submissions, and that is that Raglan is responsible for the attack upon and wreck of the Maru. And in our submission, there are two reasons for this. The first of those is that the unlawful acts of Thomas Good are attributable to the state of Raglan, and the second is that Raglan has breached its due diligence obligations. With regard to attribution, it is firstly necessary for me to establish that Thomas Good acted as an agent of the state. In this regard, our submission is that he falls within Article 5 of the International Law Commission's Articles on State Responsibility, that he was a person empowered to exercise elements of governmental authority. According to the International Law Commission's commentary to this article, a person falls within this category when the function they perform is of a public character normally exercised by state organs.
Mr. Luke, what is the status of the articles on state responsibility? How should we be looking at them as a source of law?
Your Excellency, in our submission, they are persuasive as the work of eminent publicists, and therefore the Court may have reference to them under Article 38(1)(d) of its statute. But perhaps more importantly, we submit that they are reflective of custom, particularly with respect to the rules of attribution set forth in Article 4 and 5.
Mr. Luke, only a minority of the members of the Commission are publicists.
Your Excellency, I apologise for that fact. I merely
Well, there's no need to apologise, it's a fact.
for my statement, Your Excellency, merely that as a work, it may have reference to under that part of the statute as a subsidiary sources of law. Perhaps more importantly, the International Law Commission has also stated, with reference to exercising elements of governmental authority, that reference may be made not only to the content of the powers, but the way they are conferred and the purposes for which they are to be exercised. Now, according to these broad criteria and broad indicia, we would submit that Thomas Good's role as a pilot, an imminent role within this large-scale governmental program, must be considered governmental, and must particularly be considered governmental due to the fact that the purpose of the program was to prevent injury to foreign nationals and protect them from harm, and that this in and of itself is a public and governmental function. In addition, there are a number of factors upon the facts which suggest that his role is public. He was used interchangeably with naval officials. He was selected, trained and paid by the Raglanian Royal Navy. The same flag that flew above vessels piloted by naval boats flew above vessels piloted by private contractors.
Mr. Luke, for Article 5 to work, it has to be established that the conduct in question, the conduct giving rise to the breach, was itself an exercise or purported exercise of governmental authority. How is the hijacking and robbery from a ship the exercise of the authority which Mr. Good had?
Your Excellency, our submission upon that point is if Thomas Good is considered an agent of the state under Article 5.
Article 5 doesn't use the word agent, does it?
No, Your Excellency, I'd use that term broadly to encompass both Article 4 and Article 5. I intend to, if he does act for the state, so to speak, if he exercises elements of governmental authority, then his actions will be attributable even if he manifestly exceeds his authority, acts unlawfully or contravenes instructions. That is, his ultra vires acts will also be attributable to the state.
But there's a distinction, isn't there, between ultra vires and doing acts that are outside of the function for which there might be attribution altogether. Say that the very same man who was employed as a pilot on a drunken spree rammed his motorboat against the vessel in question. Where would attributability be there, and where do you draw the line between ultra vires and acting in a private capacity, although generally your conduct may be attributed to the state?
Your Excellency, our submission is there is not one definitive test as to where to draw the line between private conduct and government conduct. However, a number of indicia have been set forth both in the work of the International Law Commission and in the arbitral jurisprudence on point. In particular, there has been a finding of attribution where a person acts within their apparent authority, or when they use the means placed at their disposal on account of their status to commit unlawful acts.
Yes.
Whereas actions amount to private conduct, where, to quote the Kerr claim, the 1929 decision of the French Mexican Claims Tribunal, where the act has no connection with the official function.
But Kerr was an Article 4 case that's concerned with members of the armed forces who use the implements at their disposal, and it's quite well established that they can be acting more or less on a spree of their own, but they're Article 4 agents, to use your word. Article 5 is a very specific form of authority, and you have to establish that Mr. Good was exercising that authority in hijacking the boat. Was the government supposed to say, oh, if you're going to hijack the boat, do it carefully?
No, Your Excellency. Our submission upon this point is that if he does fall within Article 5, then Article 7, the ultra vires positions, applies equally to this as it does to organs of the state, which fall within Article 4. So his conduct need not be directed or controlled, for instance, by the state. The state remains responsible for his ultra vires conduct. But of course, there has to be some connection, some relevant connection between his actions and his role within Article 5. And our submission is that that connection is he was given the authority to board vessels, to control vessels, and this is exactly what he did, although he went far beyond any authority he was given, although he acted quite unlawfully. Nevertheless, according to the indicia that I've stated, he did use his apparent authority to get in a position to be able to commit these unlawful acts. He did use the means placed at his disposal to do so, the flag that cloaked him with governmental authority. And there's clearly a connection between the powers he was given as a pilot, the power to control a vessel, and the unlawful act that he committed by virtue of that status. We would also submit that this is in keeping with the fundamental policy considerations which do underlie the area. Policy considerations which Professor Brownlee has likened to those of the common law doctrines of holding out and reliance. Thomas Good has been held out as the agent of Raglan. This has been relied upon. He was acting on duty when these unlawful acts were committed, and therefore there should be a finding of attribution. Perhaps the central issue of the case with respect to attribution is whether his acts can be divided up, whether his previous unlawful acts in acting as a pilot can be somehow distinguished from his later acts after he produced a bomb. We submit they cannot be by reference to the case of humans. In that case, a group of US nationals was surrounded by a group of Mexican nationals. The local authorities sent troops to alleviate the situation and protect the US nationals. However, upon their arrival, they opened fire and immediately killed one. They then joined what was described as the rioting mob in hunting down and killing the remainder. Now, despite the fact that joining a rioting mob is beyond the apparent authority of any troops, there was a finding of attribution because these troops were acting on duty, under command and as agents of the state.
But they were still Article 4 agents, weren't they, in terms of the articles? You've got to give us a case of an Article 5 agent who acts outrageously beyond the scope of the governmental authority vested in the agent, but nonetheless the acts are held to be attributable.
Your Excellency, I'd make two submissions upon that point. Firstly, that in our submission, the Article 7 cases such as human apply equally to both Article 4 and 5. Secondly, if I could refer Your Excellency's attention to the Stevens claim, which was another US-Mexican Claims Tribunal case. Now, in that case, the alleged perpetrators were not organs of the state per se, in that they were informal municipal guard organisation that had sprung up. Nevertheless, as they acted for Mexico, in the words of the Commission, and as they were under the command of a sergeant, there was a finding of attribution, even though they were not under now what would be classified as Article 4, even though they were not organs of the state. If I could turn then to the second reason why Raglan is responsible for the attack upon and wreck of the Maru, and that it has breached its due diligence obligations with respect to unlawful activities occurring within its jurisdiction. Now, there are possibly two relevant duties that are incumbent upon Raglan. The first is the duty to suppress piracy under customary international law. However, we submit this is not directly relevant, as Thomas Good's acts do not seem to amount to piracy, as they occurred not on the high seas, but within the archipelagic waters of Raglan. The second duty is that set forth by this court in the Crawford Channel case, and that is the obligation of states not to knowingly allow its territory to be used for criminal acts prejudicial to the rights of other states.
Are you saying that Raglan knew that Mr. Good was going to go off in a frolic like this?
No, Your Excellency. Our submission on this point is that they knew of the threat of piracy. They knew that electronic monitoring and constant communication with the pilot was a necessary means of alleviating that danger and a critical element of their anti-piracy program. And yet, they did not respond to the movement of the Maru from archipelagic sea lanes and through its waters and into international waters for a period of somewhere between 24 and 48 hours. Our submission is that either they failed to electronically monitor the vessel, despite the fact it was known that it was necessary to do so, or if they did electronically monitor and maintain constant communication, they failed in any way to respond to the anomalous and known danger that must have occurred to them, that the vessel had moved out of its planned route along the archipelagic sea lanes, and there had been a lack of communication with the vessel after the point in time at which Thomas Good removed all communication and navigation equipment.
Are you saying that the coastal state, at least in archipelagic waters, has an obligation to monitor every ship and to take action if there is irregular movement of the ship?
No, Your Excellency. Our submission is that once they have chosen not simply to warn other states of the danger, as was considered sufficient in the Crawford Channel case, for instance, once they have chosen to institute such a program, they must institute it with due diligence, and they have failed to do so here, as they have known of the threat of piracy, known of the necessity to to electronically monitor and maintain communication, and either failed to do so or failed to respond.
But isn't the degree of diligence relevant to whether there's notice of some hazardous cargo or other special reason to be diligent?
Your Excellency, it is submitted that there would be a due diligence would apply regardless of the cargo, in that the obligation is not to protect against environmental damage, but to protect against damage to foreign nationals and the ships that they are travelling upon. So, regardless of the cargo, the obligation remains to protect foreign nationals.
If you're right, wouldn't the state be in a worse position if it has taken measures like this than if it had done nothing?
If Raglan had taken...
Yes, if Raglan had done nothing and instituted no program, you're saying there wouldn't have been any obligation to monitor. Because they've assumed an obligation, therefore their responsibility is higher.
Yes, Your
Which
Excellency.
does something should be careful about doing it. Therefore the incentive is to do nothing.
It is our submission that they have to operate with due diligence the program that they have chosen to institute. On the other hand,
Does due diligence require them to operate such a program?
No, Your Excellency.
How do you then answer Judge Crawford's point that a state which knows it has pirates in the area discharges its international responsibilities better by doing nothing than by setting up a program and failing to do all that it might do under it?
Your Excellency, they would still be needed to warn other nations of the threat that existed, and that is in accordance with the Crawford principle. However, they have chosen not to do so, but to institute a anti-piracy program. Our secondary submission on this point is that in any event, the statements of Prime Minister Price amount to a unilateral and binding act under international law, so that his very statements that they would institute an anti-piracy program, that it would include constant communication and electronic monitoring, is in itself binding on Raglan. And this is in accordance with what this court has stated in the nuclear test cases, that statements of senior state officials may be binding upon the state when they are made publicly and with an intention to be bound.
So you're saying that he couldn't have discontinued the program either?
No,
It's a one-way street.
If he had made similar public statements to the world that the nation was planning to discontinue the program, that certainly would have been discharged all its obligations in that regard. But it did not do so, and indeed continued to operate the program. So that is the secondary source of the obligation to monitor. If I could turn now to the issue regarding the scuttling of the Maru. It is an international wrong to interfere with a foreign flagged vessel upon the high seas. Raglan attempts to escape their responsibility for this wrong on the basis primarily on the excuse of necessity. This court has, of course, recognised in the Gabsikovo-Nagumaris projects case that the excuse of necessity can preclude the wrongfulness of actions in certain strictly defined circumstances. However, it is our submission that Raglan cannot rely upon this excuse as it does not meet three of the requirements that it must. The first of those is that according to this court, a state cannot rely upon the excuse of necessity if it has, by act or omission, contributed to or caused that circumstances of necessity. Now, of course, this is reliant upon the success of at least one of my previous submissions. But the submission is that Raglan, by virtue of the acts of its agent and its negligence, its breach of due diligence, has directly and substantially contributed to the state of necessity.
But surely mustn't there be some kind of necessity that really is necessary, even if there's responsibility for Mr. Good? If this material were a ticking bomb instead of MOX, instead of something leaking radioactivity, wouldn't there be necessity without regard to the fact that it had been the situation had been caused, in fact, by the state actor?
There may indeed be necessity, Your Excellency, in the general sense of the word. However, the state cannot rely upon the international excuse of necessity to preclude the wrongfulness of its conduct when it has caused or contributed to it. So it may still have scuttled the vessel, but it would have to pay compensation to Apollonia and its nationals. So our submission is...
There's no connection between what Mr. Good did and the MOX. He apparently didn't know it was there, and he had no interest in it. I mean, whatever fault the state may have had in relation to Mr. Good is unrelated to the state of necessity associated with the MOX.
Your Excellency, certainly the scale would not have been in any way foreseeable of the damage that inevitably happened when the MOX canisters were ruptured. However, the fact that some serious damage would occur if a vessel was left adrift on the high seas with its crew detained, even some environmental damage if it was carrying the oil in its own tanks, for instance, would occur, would be quite foreseeable due to the intervention of Thomas Good in such circumstances. So it's submitted this is direct contribution to the state of necessity, even if the scale of the damage could not be foreseen at the time.
Yes, go on to your other necessity points.
Our second submission with respect to necessity is that the act taken was not the only means of safeguarding an essential interest of the state. This is due to the fact that according to the compromis, the Raglan had secured and encased the MOX canisters in conformity with international standard practice to prevent any further MOX leakage. Once the MOX canisters and the remaining MOX had been sealed, it is submitted that Raglan cannot fulfil its strict onus to show that the scuttling was the only means of safeguarding an essential interest, that the MOX canisters once sealed could have been removed and the vessel decontaminated in the same way that the Norton shallows themselves were being decontaminated. In addition, it is submitted that there was no grave and imminent peril at the time of scuttling. This is due to the fact, put simply, that the damage had already been done. 50 kilograms of MOX had already leaked onto the Norton shallows. The remaining MOX had been sealed. And therefore, at the time of scuttling, Raglan cannot show that there was a grave and imminent danger in the absence of any evidence that the vessel continued to leak substantial amounts of radiation or substantial amounts of MOX. Your Excellencies, in the alternative to these submissions, it is submitted that in any event, if Raglan can successfully rely upon the excuse of necessity, there is still an obligation to compensate Apollonia. This is due to the fact that, in accordance with Article 27 of the Articles of State Responsibility, the excuses precluding the wrongfulness of acts do not necessarily mean that the state does not pay compensation to states that are damaged by those acts. This, of course, is dependent upon the fact that Apollonia has not itself caused or contributed to the state of necessity, and that will be an issue addressed by my co-agent. But if those arguments are successful, it is our submission that even if Raglan can rely upon necessity, it must compensate Apollonia in any event.
What is the principle on which you base that if it's not wrongfulness? Does it relate to the nature of what is being carried?
No, Your Excellency, simply that although it may preclude the wrongfulness of the activities, it does not prevent the damage that was done. And if Apollonia is an innocent third state, then it deserves to be compensated in accordance with Article 27 and also this court's statements in Gabsikovo to the or that at least noted that Hungary had expressly acknowledged that a state of necessity would not exempt it from its duty to compensate. So this would only succeed if it is ultimately decided that Apollonia has not itself caused or contributed to the state of necessity, though our submission is, of course, that it was purely Thomas Good's actions and purely the negligence of Raglan which has caused the unfortunate accident that ultimately occurred. I should also briefly note that the respondent has attempted to rely upon the London Dumping Convention to excuse its conduct with respect to the scuttling. Our submission is firstly that the London Dumping Convention is not relevant to Apollonia's claim. It is not relevant because the London Dumping Convention expressly involves environmental damage consequent upon dumping. It does not in any way involve interference with a foreign flagged vessel, nor does it involve damage to foreign states' property. In addition, it is submitted that they cannot exempt they do not fall within the exemption in the London Dumping Convention, as the action taken was not the only means of safeguarding human life or human property. So,
what between the parties is the legal relevance of that convention?
I notice I'm out of time.
You have time to answer that question.
There is no direct legal consequence, Your Excellency, due to the fact that Apollonia is not a party to the London Dumping Convention. We do not attempt to assert any rights with respect to the London Convention against Raglan. We merely state that they cannot use the London Dumping Convention to excuse their scuttling of an Apollonian flagged vessel, even if they were able to meet the requirements of the London Dumping Convention, which in our submission they cannot.
Thank you very much.
Thank you. May I please the court?
Thank you for your submissions. The court now calls Stephen Colditz. Mr. Colditz, will you address us?
Madam President, Your Excellencies, the intervention of Raglan's pilot has had grave consequences for both Raglan and Apollonia. Apollonian sailors have died, and Raglanian leisure and tourism activities in the Norton Shallows have been impaired. My submissions will address Raglan's claim in respect of this impairment in two parts. The first part consists of the submission that Raglan lacks standing with respect to environmental damage that is confined entirely to the high seas. And the second part consists of two submissions. The first being that Apollonia has breached no obligation of notification with respect to nuclear transport in international law, and the second being that Apollonia has breached no other due diligence obligations in relation to the safeguards to be applied to nuclear transport through international, territorial and archipelagic waters. To turn to the first submission, through the operation of the doctrine of res communis, no state can hold an individual right or interest in the high seas, and as such, in order to invoke standing, it is necessary for the respondent to rely on the breach of an obligation owed erga omnes to the international community as a whole, by which it has been specially affected.
Is this an objection to the admissibility of the claim, or does it go to the merits?
Your Excellency?
Is the point you're making now a question of admissibility or merits?
It is a question of admissibility, Your Excellency, insofar as...
Haven't the parties agreed in the compromise to submit the issues to the court?
Yes, Your Excellency, but in addition there is, of course, the issue of Raglan's standing, insofar as that without standing, then the merits of the issue do not fall to be considered. That is to say, that the existence of a specific breach or the assessment of any wrongfulness, apart from the breach of the general obligation to preserve and protect the environment of the high seas, do not fall to be considered.
So really it's a standing question with regards to a specific merits argument rather than, as you initially suggested, a general admissibility point, isn't it?
Precisely, Your Excellency, I stand corrected.
Yeah.
Your Excellency, Apollonia submits that no obligation erga omnes has been recognised in respect of the environment by a majority of this court.
Before you go on to that, and in relation to the point you previously made to us, is it your submission then that if citizens of State A are in some manner or other on the high seas, whether they've pulled in at a shallows or they're on a vessel, that there is no obligation of State B in relation to them so far as safety and life is concerned?
There certainly are direct obligations owed in respect of the protection of citizens of other states, but this, of course, is a matter of diplomatic protection, which involves, of course, the interference with rights or interests held by individuals or held by states. And, of course, for example, we see that on the facts, had the property of Reglanian nationals, for example, been damaged by the environmental damage, then Raglan would indeed have standing on that basis through an individual wrong committed against the nationals of Raglan. But in Apollonia's submission, in the absence of such a fact, and in the presence merely of environmental damage that is confined to an area of the high seas, Apollonia must instead rely not on a direct obligation, but rather on an obligation erga omnes.
But if all parties have tolerated and known about the economic and tourist activities offshore of the nationals concerned, can it be the case there are no obligations in the environmental field that affect those activities?
Your Excellency, there is certainly a general obligation in international law to protect and preserve the environment of the high seas. In addition to that, were Raglan, for example, to have asserted sovereignty over the shallows through, for example, the acquiescence of other states to that assertion, and in that way circumventing the prohibition on the assertion of sovereignty over high seas contained in the United Nations Convention on the Law of the Sea, then certainly it would be a question of transboundary environmental damage, which is, of course, an issue of the individual rights of states as opposed to the interests of the international community.
You seem to be saying that states will have standing if they have proprietary, or if their nationals have proprietary interests, or they have sovereignty interests, but not if they have a well-attested and genuine concern with the environment. Is that the present state of international law?
Unless, Your Excellency, states can indicate that they have a particular legal interest which arises either through the interest they have in the enforcement of obligations owed erga omnes, or through some other source of legal interest, such as, for example, the existence of a preferential right on the basis of the Icelandic fisheries cases, then in Apollonia's submission that is indeed the present state of international law, because no states can exercise an actio popularis.
Well, we can talk about Latin phrases till we're blue in the face. The question is whether Raglan had an interest in the area, and it seems that they did. Why aren't they specially affected in the Article 42 sense?
Your Excellency, Raglan may well be specially affected insofar as that it has suffered economic consequences as a result of the damage done. Raglan has not, in Apollonia's submission, suffered the impairment of any legal right, and in Apollonia's submission on the fact...
Why is suffering economic consequences in a situation that has been tolerated by your adversary not sustainable of a legal right?
Because, Your Excellency, through the operation of the doctrine of res communis, no states can hold individual rights in the high seas.
But those are title rights. That is what the doctrine says. But it doesn't, does it address the question of whether activities which are acquiesced in take place? Does it go so far as to say there are no legal interests in the security of those?
In Apollonia's submission it does, with the caveat, though, that of course individual rights of user exist in the high seas as a unified general concept, as opposed to rights of user over a specific area of the high seas. And Apollonia's submission is therefore that there must be an obligation erga omnes established. And indeed, the question of whether Raglan has been specially affected by that breach would indeed. Apollonia's submission is that the core indicia, as has been recognized, for example, by the International Law Commission in its commentary to the Articles of State Responsibility, and by such eminent publicists as Dr. Ragazzi, of obligations erga omnes, is that they are all drawn from obligations and rights of a jus cogens character, and as such represent preemptory norms from which no derogation is permitted in international law. And indeed this is certainly true of all of the obligations that have been recognized to have erga omnes character in, for example, the Barcelona Traction case, the East Timor case, and the very recent Wall Advisory opinion.
Let's assume that I have a well-established tourism operation in the Antarctic, no sovereignty claims recognised, but I regularly do it and everyone knows that, and you pollute the Antarctic in such a way that I can't do it anymore. You're saying I don't have standing in that situation?
Except insofar as that states would have standing potentially under the relevant treaty obligations on point. Apollonia submits that no, the doctrine of erga omnes and the prohibition on actiones popularis in international law would operate to prevent the enforcement through legal action of the general obligation that exists in respect of the environment. Of course, the general obligation that exists in the environment is fully enforceable through other international means, and in particular, the diplomatic process. Your Excellency, if I may return to my earlier submission about erga omnes being obligations that have, or rather obligations that are coextensive with obligations and rights owed jus cogens. Apollonia submits that it is quite clear that the general obligation to protect and preserve the environment of the high seas that has been recognized in this court, for example, in the nuclear weapons advisory opinion, is not of a jus cogens character because it has not been accepted by such as states, and this is evident from state practice in polluting the high seas, and it is even evidenced in such conventions as the London Convention, which allows dumping and indeed pollution to the high seas in particular circumstances, and as such the obligation not to pollute the high seas.
Does the allowing of exceptions or circumstances definitionally mean you've not got a jus cogens issue?
Insofar as that those exceptions represent derogations under, for example, Article 53 of the Vienna Convention on the Law of Treaties, in Apollonia's submission it does indeed indicate that there is no room for the recognition.
Is the use of force aggressively a jus cogens prohibition?
There is a prohibition on acts of aggression, Your Excellency, yes.
And if you may use force defensively in exceptional circumstances that are indicated, do you no longer have a jus cogens right?
In Apollonia's submission, the use of force in defensive circumstances would not constitute an act of aggression, and as such...
So the point I'm making is, can you really tell whether the character of a jus cogens right can be identified by reference to whether there are exceptions to the general rule?
Your Excellency, insofar as that it is appropriate to look to the practice of states in recognizing the existence of a right jus cogens, in Apollonia's submission it is indeed appropriate to look at exceptions that exist in principle and to look at exceptions that are taken and indeed exercised regularly as a matter of state practice.
The obligation to protect and preserve the marine environment is stated in the Law of the Sea Convention as an obligation on all states, not on states' parties. Isn't that evidence that we're dealing with an obligation of a general character? I avoid the Latin.
Indeed, Your Excellency, we are dealing with an obligation of a general character, and this is recognized in the court's...
An obligation of general character that doesn't have any meaning because it's not enforceable.
Indeed, Your Excellency, it does not have any legal power of enforcement because it is clearly an actio popularis as a general obligation, and unless it can satisfy the indicia that have been recognized for the existence of obligations erga omnes, and in Apollonia's submission it cannot, then it cannot be enforced under, for example, the procedure set out in Article 42(2)(a) of the International Law Commission's Articles of State.
Wasn't the whole idea of the greatly inflated erga omnes principle in Barcelona Traction one that related to standing?
Indeed, Your Excellency.
Precisely related to standing to bring a claim.
Indeed, Your Excellency, and this is still my standing point. Perhaps, Your Excellencies, I might move to the broader merits issues. In Apollonia's submission, there is no general obligation in international law to notify states of the transport of nuclear materials, and there are four aspects of this submission. The first is that customary international law quite clearly does not incorporate any obligation to notify states, because there is inconsistent state practice and because there is emphatically no opinio juris in support of the existence of such a customary obligation. Nuclear exporting states do not consistently notify states of the fact of nuclear transport through their exclusive economic zones and territorial waters. And this is clear, for example, from the Irish submissions in the Mox plant case. In addition to that, those states that do notify, and indeed this is clear, for example, from the public positions of the nuclear exporting states taken in the negotiations on the joint convention, when they do notify, they do so not on the basis of any recognized legal obligation, but rather in the interests of international comity. In addition to that, those states that have objected to the transport of nuclear materials through their territorial waters, and indeed in some cases have legislated to prevent the transport of nuclear materials through their archipelagic and territorial waters, have done so not on the basis that there is any legal obligation that should be recognized, but rather on the basis that it represents, or the recognition of such an obligation represents, a desirable progressive development in international law, or indeed is merely prudent as a question of politics.
Do these general observations get qualified at all if there is a known danger other than what is being transported in the area, dangerous rocks or pirates?
There is no evidence of any such objections being qualified in the evidence of state practice, Your Excellency, in Apollonia's submission.
Is there a due diligence obligation on someone transporting MOX to take steps appropriate to these kinds of particularized risks that might be known?
Indeed, Your Excellency, and perhaps if it please the Court, I shall move now to the due diligence
Yes.
obligation and, time permitting, return to the notification point. Your Excellencies, Apollonia submits that it has adhered to its due diligence obligation in international law because in the International Atomic Energy Agency's own assessment, it has adhered to international standard practice in the transport of MOX fuel.
But is there a standard for transporting in waters infested by pirates?
No, Your Excellency, there is, of course, the fact that the standards, the physical protection standards, have been developed in order to ensure the physical protection of material, whether it be the physical protection from a pirate threat or the physical protection from the threat of some other malefactor. And this is alluded to, for example, in Security Council Resolution 1530. And so, Your Excellencies, because Apollonia has adhered to international standard practice, which the 1993 United States Department of Energy report considered to be adequate to give rise to a very high level of safety in relation to the transport of nuclear material, Apollonia submits that it has indeed adhered to the due diligence standard in international law.
So you're separating notice from due diligence. You don't consider the possibility of giving notice of transport of this type of material to be an aspect of the appropriate due diligence.
Oh, it is indeed, because the giving of notice is intrinsically interrelated with the physical protection of material. And this is recognized, for example, in Fundamental Principle L in the International Atomic Energy Agency's document, Physical Protection Objectives and Fundamental Principles, which recognizes, and I quote, "States should protect the confidentiality of information, the unauthorized disclosure of which could compromise the physical protection of nuclear material and of nuclear facilities." And Apollonia therefore submits that maintaining the confidentiality of nuclear transport is indeed a physical protection measure and, in the circumstances, potentially an essential physical protection measure.
Maintaining the secrecy from the people who would stand to protect the shipment, the Raglan Navy? Is that the proper standard of care?
In Apollonia's submission, it is not, because the relevant standards in international law do not require any notification of other states, and the relevant standards are intentionally designed in such a way by, for example, the International Atomic Energy Agency and by the International Maritime Organization to, of themselves, ensure adequate physical protection for nuclear material without the reliance upon any third party or upon the Navy or indeed the expertise of any other state.
Mr. Colditz, did you not take a risk in running a cargo of MOX through the archipelagic waters of another state without notification in situations where there was a problem of piracy? I mean, are you saying that they have to show due diligence but you don't?
No, Your Excellency. Apollonia's submission is that, to begin with, on the facts, the level of pirate attacks in the central archipelagic sea lane of the archipelago is very much reduced from what it was in 1999 when the International Atomic Energy Agency conducted its assessment. And we see this in, for example, paragraph 12 of the compromise, where it becomes clear that no pirate attacks have in fact taken place in the relevant area in 3 years of the transport, or within the 3 years prior to the transport of the Maru along a route that was chosen by the expert captain of the vessel, who was experienced in the shipment of nuclear materials, on the basis that such route would minimize the pirate threat presented. Your Excellencies, if I may address very briefly the issue of the hortatory standards to which the International Atomic Energy Agency refers in its Information Circular number 225, and which have been rejected by states as being of mandatory status. Your Excellency, it is possible that technical breaches of these standards have indeed occurred. But at the same time, Apollonia submits that these recommendatory standards do not constitute the due diligence standard in international law. Because, for example, we see in the state practice of major nuclear shippers, and in particular the state practice of the United Kingdom and of France, as it has recently been assessed by consultants retained by the International Atomic Energy Agency, these states themselves do not comply with the mere hortatory advisory recommendations contained in the Information Circular 225. These recommendations are put forward by the International Atomic Energy Agency as a ne plus ultra best practice standard for the transport of nuclear materials. They are not adhered to. They have not, pardon me, Your Excellencies, they are not adhered to by all major nuclear transporters. And indeed, the international community has rejected, for example, at the General Conference of the International Atomic Energy Agency in 2001, the incorporation of such safeguards into mandatory status. Yes. And as such, Apollonia has complied with its obligations.
Thank you very much indeed.
May it please the Court.
May it please the Court. My name is Siti Aliza alias, appearing on behalf of the respondent, the Kingdom of Raglan. With me is my co-agent, Ms. Melati Abdul Hamid, and table counsel, Mr. Eng Boom Ka. Your Excellencies, me and my co-agent will each be taking 21 minutes of this Court's time, and we reserve 3 minutes for rebuttals.
Yes.
Your Excellencies, I will be dealing with 2 issues. Firstly, regarding the scuttling of the Maru, and secondly, regarding the piratical attack and piratical activities in the archipelago, and the other 2 issues will be dealt with by my co-agent. And I shall begin with Raglan's first submission, that it is not responsible for a breach of international obligation in the scuttling of the Maru, because the scuttling of the Maru was done due to exceptional circumstances that justify its action. Your Excellencies, the Kingdom of Raglan is invoking its right as a coastal state to take defensive enforcement measures upon a foreign vessel on the high seas when there is a threat to the interests of its coastal nation, Your Excellencies. This right, known under international law as a coastal state's right of intervention, we submit is a rule of customary international law. This is because
what sort of threat? You put it at a rather low threshold when there is a threat to the coastal state. Does it not have to be rather more than that?
Your Excellency, according to the Intervention Convention, the threat must be an imminent threat. But according to UNCLOS, merely a threat to the coastal state and or its related interests. But we will prove to this Court that there was an imminent threat. Firstly, I shall establish that the rule on intervention itself is a rule of customary international law because it has been adopted. Firstly, it has been acknowledged by the ILC in its report in its 1980 yearbook. And furthermore, the rule of intervention by a coastal state has been adopted in various international conventions and instruments. For example,
Mr. Elias, you talk about coastal state, but this occurred outside the EEZ. And as I understand the facts, there was no actual pollution of any area over which the respondent had sovereignty or sovereign rights. That being so, weren't you just in the position of any other state?
precisely the rule of intervention, Your Excellency, is that when there is a threat of pollution that will threaten the coastal state, that will threaten the interests of the coastal state, although the pollution has not yet reached the territorial waters of the coastal state, it gives right to the coastal state to intervene on the high seas upon a foreign vessel in order to stop the threat of the pollution from spreading to its coastal nation, Your Excellency. For example, in the Torrey Canyon case, where United Kingdom had bombed a Liberian oil tanker outside the territorial waters of United Kingdom, because there was a threat of the oil pollution spreading and endangering the interests of United Kingdom in its coastal area, Your Excellencies. And in our case, the MOX pollution had happened on the high seas. However, the threat here, the imminent threat here, is the coming rainy season and also the prevailing strong ocean currents moving southeasterly towards Raglan inhabited island. And if
What do you say to the point that the necessary sealing of the canisters had been done? How did that affect the imminence and reality of the threat?
On that point, Your Excellency, our response is that to actually secure and encase MOX canisters in conformity with international standard is actually part and procedure of the scuttling itself, and this has been acknowledged by the Nuclear Technology Institute of Washington, D.C. in one of its circular that to secure and encase the canisters itself is part of the procedure of scuttling in order to ensure that the substance, radioactive substance, would not later leak when it has been dumped underwaters. Furthermore, Your Excellency,
Can you at the same time say that there nonetheless remained immediately prior to that scuttling an imminent threat? I mean, on the one hand, you're saying, and I understand the point, that the sealing is a part of the required process of scuttling, when scuttling might exceptionally be permitted, but you're saying that having done that sealing of the canisters, there still remained an imminent threat that required the scuttling.
yes, Your Excellency, and Raglan submits so due to two reasons. Firstly, the securing and encasing of the MOX canisters itself is only to prevent further leakage, but it does not stop the radioactivity of the cargo itself. And secondly, the ship, the vessel, the Maru itself, has been contaminated with radioactive substance. Therefore, the ship itself has been radiated, and it poses a threat to the environment if the coming rainy season would transfer the pollution from the contamination in the ship itself to the waters, Your Excellency. This is because...
How serious was the contamination of the ship as distinct from the MOX which had been encased?
Your Excellency, this is because the MOX canisters had leaked through the ship.
Yes, I understand that, but
yes.
do we know how serious the contamination of the ship as distinct from the encased cargo was? Was the ship itself seriously contaminated?
We would submit so, Your Excellency. This is because we have to look from the nature of the pollutant itself. That is, it is not a mere pollutant like oil, but it is a nuclear substance which is highly radioactive, and the nature of nuclear substance itself, that it can transmit not only via air or water, but via direct contact with any matter, Your Excellencies. And Your Excellencies, on this point, Your Excellency, we would... may I be given a moment?
Yes. Take a little drink, and we've probably pressed you enough on that point, and we'll be ready for you to go on to the next point.
Your Excellencies, much obliged. Then I shall submit that the requirements of the coastal states' right of intervention has been met. This is because there was an imminent threat due to the nature of the MOX pollutant itself, and this has been explained in the MOX plant case that MOX is an ultra-hazardous substance that can pose great danger to human health and the marine environment, Your Excellencies. And if it is to spread to the nearby inhabited island of Raglan, it would endanger human lives in the inhabited island, Your Excellencies. And furthermore, Your Excellencies, the other element is that there must be an essential interest to be protected by the coastal state. And here we submit that the essential interest is not only the health and safety of the coastal population, but also the commercial fishing and tourist interests and the conservation of the marine environment. This is because, Your Excellency, Raglan has an obligation to protect the marine environment because it is a party to the United Nations Convention on the Law of the Seas. And under Article 194 of that convention, Raglan has the obligation to protect the marine environment.
How much does it matter that both parties in this case are not parties to the same Law of the Seas conventions? Is that relevant?
Your Excellency, we submit that although Apollonia is not a party to the UN Convention on the Law of the Sea, but it is a party to the high seas. And when the rights in two conventions are similar, therefore both states shall be bound by the same rights and obligations, Your Excellency. Your Excellency.
Would you say that you're entitled to rely on the convention because it's as it were the main instrument in force in the world dealing with that subject matter, and the fact that they haven't ratified is irrelevant? In other words, you have rights under the convention, which their non-ratification doesn't affect.
Your Excellency, may Your Excellency repeat the question,
Yes, of course.
please?
Yes, I mean, I understand Agent Alias to have made a different point, but she'll tell me if I've understood correctly, that the issue is not whether it is the general convention notwithstanding ratification, but that each have undertaken the same, essentially the same right in different instruments. Has the bench understood you correctly?
Yes, Your Excellency. And Your Excellency's concern would be?
No, I think that answers the question.
Much obliged, Your Excellencies. And Your Excellencies, the third requirement to invoke this right of intervention, that the action must be proportionate to the danger. And we submit that our action is proportionate to the danger. This is because the only, on a balance, the interest that Apollonia seeks to protect is its interest in the vessel, the Maru. However, the vessel itself has been severely damaged and also is contaminated with radioactive substance. Therefore, any interest that Apollonia might have in the vessel is now highly negligible, Your Excellencies. On the other hand, the scuttling of the Maru had been proven to have stopped the threat to the coastal nation of Raglan. This is because, Your Excellencies.
Can you say that an interest in the vessel has become negligible when it's the case of your opponents, that has been exactly through wrongful actions of your agent? Is that a proposition you can seriously make?
Your Excellency, what is meant by Raglan, that the interest of Apollonia in the vessel is negligible, this is because if we balance the interests of Apollonia and Raglan, the interest of Apollonia is on a vessel that is already severely damaged because of the accident and is already contaminated with radioactive substance. On the other hand, the interest that Raglan seeks to protect is the interest of its coastal nation, the lives of its population there, the marine environment, and its obligation to protect the marine environment. And furthermore, from the compromise and clarification, we can see that the scuttling was an effective measure to stop the threat of the further spread of the pollution to Raglanian inhabited island, because in clarification paragraph 4, it was scuttled in an area where the cargo and the vessel will no longer, and the substance, radioactive substance, will no longer move, as it is protected from wind and ocean currents. Furthermore, after years of the vessel had been scuttled, only traces of radiation can be seen 25 kilometers from Raglan EEZ. Had Raglan not scuttled the Maru, then the radiation would have spread even nearer. Furthermore, Your Excellencies, scientific research produced by the Nuclear Technology Institute of Washington, D.C. had concluded that to scuttle a vessel containing radioactive substance or any other method of dumping underwater when it involves nuclear substance is the most effective way that can be seen as of now.
Was that something that Raglan consulted Apollonia about as to what the most effective way to deal with the problem would be?
Your Excellency, we shall submit that firstly, because it is a situation of extreme urgency and emergency that gives us the right to intervene, there is no customary international law rule on the obligation to consult, Your Excellency. And in any event, it is for Apollonia to prove to this Honourable Court that Raglan has the obligation to consult. Alternatively, Your Excellency, if the bench feels that there is a customary international law rule on the duty of consultation, then Raglan submits that we had already done so and discharged our obligation. This is because of the 2 diplomatic notes sent by Raglan to Apollonia. Firstly, that Raglan had inform Apollonia that there are pollutants in the high seas near to Raglanian inhabited island from its Apollonian own vessel, Your Excellency. Apollonia did not respond with any offer to help or to assist Raglan in decontamination and to stop the threat, Your Excellency. Secondly,
did you give them enough time to respond?
Yes, Your Excellency. This is because the diplomatic note was sent on July 31st, 2002, and they did not respond until August 4th, 2002. And on August 4th, another diplomatic note was sent to inform that we would have to scuttle the vessel because we have no other choice due to the imminency and the time factor that is present in the situation, Your Excellencies. However, again, Apollonia failed to respond or even to protest if it feels that we should not have scuttled, we should not decide to scuttle the vessel, or it should have offered other means to help us, knowing that there is a grave threat there, Your Excellencies. Therefore, we shall submit that we have discharged our obligation to consult Apollonia, and in fact, Apollonia was the one who did not respond in good faith to our consultation, Your Excellencies. Your Excellencies, I shall move on to Raglan's second submission, that it is not responsible for the piratical attack and the piratical activities in its archipelago. Your Excellencies, my submission on this point is twofold. Firstly, we shall submit that the act of Thomas Good is not attributable to Raglan, and secondly, that Raglan has not breached any of its obligation to respond appropriately to piratical activities in its archipelago. On the point of attributability, Your Excellencies, agent for Apollonia submitted that there is no definitive test in differentiating between an act carried out within official capacity and an act carried out within private capacity of an agent. We submit that by virtue of the ILC commentary to Article 7, the definitive test here is whether that agent, when he carried out the wrongful act, was acting within the apparent authority given to him, Your Excellencies. Your Excellencies, in the commentary to Article 7 by the ILC, it is clear that when an act is so far removed from the scope of the official function of that agent and that it should be assimilated to an act of a private individual, then the acts are not attributable to the state, Your Excellencies. Also, Your Excellency, commentary to Article 7 expressly stated that the distinction between official conduct and private conduct needs to be made in situation of isolated instances of outrageous conduct on the part of state organs. We submit that the act of Thomas Good is an isolated act, and also it is an outrageous act that no person can be reasonably expected to see the act of Thomas Good as an apparent act within his official capacity. And indeed, Your Excellency, when he threatened to detonate the explosive device, he had detached himself from the authority given to him by Raglan. And when he steals from the ship's safe and equipment, it is clearly committed for private ends and no longer within his official capacity, Your Excellencies.
That's the last. Sorry.
but a plan, let's say, was formulated by Mr. Good with others before he got on board the vessel, while he had his hat on as a pilot, while no one could know that he was formulating this plan. He formed an intent and acting with that intent, got on board the vessel, and then you say at some point it became so far beyond the apparent scope of what he was supposed to do that everyone should have recognized it. Wasn't he already committing wrongful acts at that point for which the state was responsible?
Your Excellency, on that point, Raglan submits that when he boarded the Maru, true, he was acting as an agent. And when he piloted the Maru, he was acting as an agent. But the apparent authority ceased from the moment he threatened to detonate the explosive device, because at that point, it was no longer apparent to the other side that he is still acting as an agent. This is the test that has been stated in the commentary to Article 7. And why Raglan says so is because the captain of the Maru himself knew that Thomas Good, at the point when he threatened to detonate the explosive device, is now not an agent but a pirate, because clearly in the compromise, paragraph 11, it is stated that the captain, knowing that pirates from Raglanian archipelago would not normally harm their victims, he gave control of the vessel to Mr. Thomas Good, which meant that he knew Mr. Thomas Good is a pirate and no more acting as an agent of Raglan.
Ms. Elias, you're putting this argument, it seems to me, on the basis that Mr. Good was an agent, that is covered by Article 4 of the ILC articles. Is that your position? Counsel for the applicant argued this on the basis that the relevant article is Article 5, that is someone in the private sector who is authorised to perform governmental functions. You say Article 5 is the wrong article, do you?
No, Your Excellency, we admit that he is an agent under Article 5. However, we submit that his act is so far removed from the scope of his official function that he is no longer acting within his official function, but within his own private function, and therefore by virtue of commentary to Article 7, when an agent acts within his own private capacity, then the act is not attributable to the state.
So your position is that even if Mr. Good had been a member of the armed forces wearing the armed forces uniform, the state would still not have been responsible for his conduct?
Yes, Your Excellency, because the rule in Article 7 is applicable to both an organ under Article 4 and an agent under Article 5. Furthermore, Your Excellency, we submit that by virtue of the care claim case, that when an act had no connection with the official function was, and in fact merely the act of private individual, it is excluded from attributability. What can be distinguishable from the acts of Thomas Good and all the attributability cases, for example in care case and also in Newman's case, is that in care case, to shoot another individual, and in Newman's case, to open fire, is an extension of the normal exercise of power of a soldier or an army. However, to commit piratical acts and to steal from ships safe is not the normal extension of the public power of an assigned pilot, Your Excellencies. And the means that was used by Mr. Thomas Good to commit the wrongful act is his own explosive device and not one that is given by Raglan, and that is another distinguishing factor from the care claims case, Your Excellency. I see that my time is only 1 minute remaining. I shall quickly move to the second part, that Raglan has not discharged, has not failed to discharge its obligation to respond to piracy with due diligence. This is because the nature of the duty itself, as acknowledged by Apollonia, is due diligence, which means that it is not an absolute duty, Your Excellency, which means that as long as Raglan had exercised its obligation in good faith, that there is no continuing disregard of its obligation, then an isolated case, a mere anomaly in... May I be given a moment to finish my
Complete your
sentence?
proposition on this,
That
yes.
the occurrence of a single crime, Your Excellency, an isolated case, cannot negate the overall effectiveness of the anti-piracy program, which has been acknowledged by ILSA because it reduced the alert level warning, and it has been successful for over 2 years, Your Excellencies.
Thank you very much for your submission.
May it please this Honourable Court.
The court now calls upon Ms. Hamid.
Madam President, Your Excellencies, a very good evening. May it please this Honourable Court, my name is Melati Abdul Hamid, representing the Kingdom of Raglan, the respondent in the present proceedings. I propose to take 21 minutes of this Honourable Court's time in order to submit on two main arguments. Raglan's first main argument is that Apollonia has an international obligation to give prior notification to Raglan with regard to its smoke shipments through Raglanian archipelagic waters, and Apollonia had failed to do so. Secondly, Apollonia also has an international obligation to pay compensation to Raglan for the damage at the Northern Shallows for the injuries suffered by Raglanian ecotourism and sport fishing industries there. Each point will be dealt with in turn. Your Excellencies, may I begin my submissions proper?
Certainly.
Much obliged. With regard to the first submission, we submit that Apollonia has an international obligation to give prior notification to Raglan with regard to its smoke shipments through Raglanian archipelagic waters. Your Excellencies, the Maru was exercising the right of sea lane passage while traversing through Raglanian waters. This is due to the fact that, according to the clarifications, Raglan had designated sea lanes and the Maru followed these sea lanes in its passage, and by virtue of Article 53 of the United Nations Convention on Law of the Sea, they have the right of sea lane passage. However, Your Excellencies, by virtue of Article 39 of the Law of the Sea Convention, it states that ships in sea lane passage shall comply with generally accepted international regulations, procedures, and practices for the prevention, reduction, and control of pollution.
Now, is this a proposition of general international law, of customary international law, or is it special to the convention?
With regard to the right of sea lane passage, Your Excellencies?
Yes. Control over sea lane passage transit.
We submit that it has arisen into customary international law by virtue of what state practice with regard to archipelagic states, Your Excellencies, since this right of sea lane passage and the obligations thereof is specially affected by archipelagic nations, and there is no archipelagic nations which has protested or rejected the existence of these rights and obligation with regard to sea lane passage, Your Excellencies. And we submit that Apollonia has failed to exercise due diligence in conforming with generally accepted international regulations with regard to the prevention of pollution in their exercise of sea lane passage. Your Excellencies, we would like
Ms.
to...
Hamid, the applicant argues that in fact by not notifying it was improving the chances of this consignment not being interrupted. In other words, they say that it was actually part of the process of avoiding pollution not to notify. What's your answer to that?
Your Excellencies, it is true that the agent of Apollonia invoked the reason of security for them withholding the information from Raglan. However, our response to that is that by notifying Raglan, it would have ensured the safe passage of the Maru. This is due to the fact that by referring to the statement made by Prime Minister Price, it is clear upon notification, Raglan could have provided armed naval escort vessel to the Maru. This would ensure the safe passage of the Maru and would have prevented the piratical attack by Mr. Thomas Good and further ensuring the safety of the coastal state, Raglan, Your Excellencies. And therefore, it is clear that the proposition by the Republic of Apollonia that withholding the information would ensure the security of the physical protection of the nuclear material is not true.
Is the practice of states who transport MOCs to notify other states?
Your Excellencies, there have been many state practices with regard to the duty to give prior notification. For example, there are two regional customs which have codified the duty to give prior notification into their joint protocols. The Mediterranean nations in the Protocol on the Prevention of the Pollution of the Mediterranean Sea and the Association of the Caribbean States in 1999 had made joint declaration of their recognition of the duty to give prior notification for nuclear ships traversing through their waters. Furthermore, more than 100 states have incorporated this duty into their national legislations, states including Canada, Egypt, Djibouti, Saudi Arabia, Iran, Oman, Philippines, Turkey, and Portugal, Your Excellencies. Furthermore, we would prove that other states have taken the extreme measures of trying to stop the passage of nuclear ships traversing through their waters without prior notification by using naval ships. This shows that these coastal states regard this obligation of prior notification as a legally binding obligation, and ships that fail to conform to this duty had conducted an illegal act under international law. Furthermore, Your Excellencies, we would like to refer to the Nicaragua case, whereby it states that this Honorable Court acknowledged that a practice does not always have to be followed for it to indicate a custom. It is sufficient that any departure from it is recognized as illegal. From the illustrations that we have submitted before this Honorable Court, therefore we submit that there is a customary duty to give prior notification to coastal states for nuclear ships. Your Excellencies, our alternative argument is that there is also...
What do you say to the argument from your opponents that the real major transporters, and the United Kingdom and the United States were mentioned, do not regard themselves as under a legal obligation to notify? How do you put in the balance that practice against stated positions by large numbers of countries who are probably not much in the business of transporting MOCs?
Your Excellencies, with regard to the duty to give prior notification, the specially affected states are the coastal states through whose waters the nuclear materials are being transported. This is due to the fact that they are not benefiting from the transportation, or most of them are not benefiting from the commercial gains of the transportation, export and import of the nuclear materials. However, their security is put at peril by the transporting states not giving prior notification.
My point's a different one. It is the quality of practice in terms of those engaging in it to show there is a custom. Does it have to be those who are most frequently engaged in the activity? Leave outside the position of the coastal state for the moment. But those who are engaging in transport, does it have to be those who do it most frequently, or a larger number of those who don't much do it, to show you where customary practice lies?
Your Excellencies, I'm afraid that I'm unable to comprehend Your Excellency's question.
Can I try this time? Yes. Let's assume that you have a custom which would depend, if it was accepted, on the consent of two different groups of states. That's frequently the case. There are, for example, landlocked states and coastal states through whose territory they have to go. Are you saying that it's sufficient if one of those groups insists on the rule, or do they both have to insist on it?
Or to sharpen it up, if it was an emerging customary rule on outer space, is it important that it includes the real outer space countries, or does just a large number of those who've never shot anything higher than 10 yards count as much?
Yes, Your Excellencies. Responding to Your Excellency's concern first, with regard to the illustration of landlocked states and coastal states, of course the practice of coastal states would be taken into consideration in determining of the status of the obligation to give prior notification for nuclear ships traversing through their waters. It is more relevant than the opinions of landlocked states. Referring back to Madam President's illustration on outer space obligations, it is clear that the states conducting or involved in outer space activities conduct would be relevant in determining international obligation with regard to it. Yeah. However, in this case, with regard to the international transportation of nuclear materials, the practice of the coastal state have been consistent to require prior notification from transporting states, and they are not separate from the activities itself. They are not separate in the sense that states, landlocked states, or states which have no interest at all in outer space activities, Your Excellencies. Therefore, the practice of the coastal states here have weight, and by virtue of the Nicaragua case, since the majority of coastal states regard the transportation of nuclear materials through their waters without prior notification as an illegal act, therefore, there is a customary obligation upon Apollonia to give prior notification to Raglan. Your Excellencies,
Please go to your next point, yes.
our alternative argument on the prior notification is that Apollonia has breached its international obligation to give prior notification under the precautionary principle and international environmental law. Your Excellencies, a state can exploit its resources, but it also has a duty not to harm other states by activities within their jurisdiction or under their control. It follows that a state must act due diligently if there's a likely harm to another state. Then they also have an international obligation to inform the state that is most likely to be affected by their activities. Your Excellencies, I would like to refer Your Excellencies to some evidence of the obligatory nature of this duty to give prior notification under the precautionary principle. Firstly, the Rio Declaration on Environment and Development, particularly Principle 19, states that a state shall provide prior and timely notification to potentially affected states on activities that may have a significant adverse transboundary environment effect to the other state. Furthermore, this principle had been upheld in the Stockholm Declaration and also had been included into the International Law Commission draft article on prevention of transboundary harm, especially in Article 8, Paragraph 1 of the draft article. Your Excellencies.
Is this harm transboundary harm?
Yes, Your Excellencies.
Why? I mean, we're talking about transit through the archipelagic state. It's your archipelagic state, so what's transboundary about it?
This is because the origin of the pollution would be from the ship, which is under the control of Apollonian government. Therefore, there is transboundary harm from the Apollonian ship to Raglanian waters, Your Excellencies.
Are you saying that the ship itself is sort of an external, a piece of floating territory? For
No,
example?
Your Excellencies, that is not our proposition. However, under the precautionary principles, it states that activities under the state's jurisdiction or control. So in this case, we submit that the activities of transporting MOCs with their own carriers under government programs is an activity under the control of Apollonian government, Your Excellencies. Furthermore, this duty to give prior notification had been upheld in several tribunals and courts' decisions. Firstly, the MOCs plant case, which had been decided by the International Tribunal of Law of the Sea, which is a dispute between Ireland and the United Kingdom. It was held that there was an obligation of due diligence when engaging in activities which might have an impact upon another state, and the obligation to exchange information is one of these, Your Excellencies. This further had been upheld in the land reclamation case between Malaysia and Singapore, in the Lac-Lanox case between France and Spain, and also by this Honourable Court in the Gapchikovo-Nagimaros case, whereby in the separate opinion of Judge Wiramantri, he had specifically acknowledged the concept of exchange of information had gathered much recognition under international law, and this Honourable Court must give due notice to it.
Was that, you said it was held by the court, was the opinion of the very learned judge reflected in the court's judgment?
No, Your Excellencies. It is true that the judgment of the court did not refer to the precautionary principle. However, Judge Wiramantri did refer to it. Your Excellencies, in this case, we submit that there is a significant risk of harm to the Raglanian territory due to the nature of the MOCs being transported through our waters. Firstly, Your Excellencies, according to the IAEA final report, in paragraph 9 of the compromise, it states that MOCs is shipped without adequate safeguards on private vessels through waters known to be frequented by pirates. And after this notice given by the IAEA, Apollonian government had continued to transport MOCs with private vessels and there was no naval escort vessel provided by the Apollonian government, and the ship, like the Maru, was manned by only a small crew. And this was done through waters. The route chosen was through waters known to be frequented by pirates. Your Excellencies, this gives rise to a significant risk of harm to Iranian waters.
But how can you say you met your due diligence tests and that had been shown by the fact there had not been attacks for the past previous years, and say at the same time there was an obligation to notify when going through waters that were known to be risky?
Your Excellencies, firstly, Raglan had discharged its due diligence obligation with regard to its response to the piratical problem. This is due to the fact that it had established an anti-piracy program which, yes, Your Excellencies, had lessened or reduced the piratical attack within our waters. However, the waters was not 100% safe from pirate attacks. This can be seen from the fact that although ILSA had reduced the warning level from 4 to 5, from 5 to 4, there is still a quite high threat of pirate attack, and we have exercised that due diligence obligation to suppress piracy by the mere fact of the continuance of the anti-piracy program until the piratical attack level has been reduced to minimal number, Your Excellencies. Therefore, Your Excellencies, we submit that since the transportation of MOX was not done with due diligence, they did it with only by private carriers manned by a small crew and through waters known to be frequented by pirates. Therefore, there's a significant risk of harm, and therefore, Apollonia has an obligation under the precautionary principle to give information to Raglan in order for Raglan to be able to respond appropriately and to ensure the safeguard of the passage and the security of Raglan as a coastal state. Your Excellencies, may I move on to my second submission?
Yes, you have a few minutes left for that.
Your Excellencies, with regard to the compensation, the first agent of Apollonia stated that there was no causal link between the damage and the wrongful act conducted by Apollonia. Here, the wrongful act is transporting MOX without prior notification to Raglan. The damage was to the Northern Shallows, and the injury suffered by Raglan is the loss of profits of its ecotourism and sport fishing industries, which had been carried out at the Northern Shallows for nearly 15 years. Your Excellencies, there is a causal link between the wrongful act and the damage to the Northern Shallows. Firstly, due to the radioactive nature of MOX, states such as the United States of America in its Restatement 3rd of the Foreign Relations Law and Germany on its legislation on civil liability for environmental damage had stated that there is a presumption of causality between the wrongful act and the damage when it concerns radioactive, dangerous, ultra-hazardous radioactive materials such as MOX. Furthermore,
Hamid,
yes,
how do you respond, and you can do this very briefly, how do you respond to their argument you don't have standing to raise this point?
Your Excellencies, with regard to our standing, with regard to the argument on obligation erga omnes, we are invoking Article 42, Paragraph B, Paragraph 1, in order to prove that we have standing before this Honourable Court. Raglan, there is a breach of obligation erga omnes. This is due to the fact that under Article 194 of the United Nations Convention on Law of the Sea, each state must take all measures necessary to ensure that activities under their control would not cause pollution. And as had been illustrated before, Your Excellencies, Apollonia had not done so by not notifying Raglan of the MOX shipments through our waters. And by virtue of the nature of the high seas itself, in Article 87, it states that all states have equal legal interests and rights over the high seas, since the high seas are open to all states for peaceful activities. And therefore, since obligation erga omnes is an obligation owed to the international community, and since the high seas is an area whereby all states have legal interest over it, it follows that pollution on the high seas is a breach of obligation erga omnes. As had been illustrated by the International Law Commission in its commentary to Article 42, paragraph B, paragraph 1, Your Excellencies.
Surely Article 42 is concerned with specially affected states, not with obligations erga omnes, which is the subject of Article 48. Are you saying you were specially affected?
Yes, Your Excellencies, Raglan is a specially affected state. This is due to the fact that to be a specially affected state, the state must have suffered some injury which is distinguishable from other states to which the obligation is owed. In this case, Raglan had suffered. Raglan is the only state in the international community which had suffered loss of profit to its ecotourism and sport fishing industries, which had been carried out at the Northern Shallows for nearly 15 years. And Your Excellencies, referring to the definition or the commentaries on the term of injury, it states that it includes any damage to other interests of state as long as it is financially accessible and established in nature. In this case, the facts shows us that Raglan is not claiming for the mere damage to the environment or for the loss of species. It is claiming, Your Excellencies, may I just finish my proposition?
Yes.
It is claiming for the loss of profits of its ecotourism and sport fishing industries, which had contributed steadily to its tax revenue, but of about 160 million a year. This shows that the claim is economic in nature and is not intangible or financially inaccessible. With regard to the established... Yes,
so that means you really abandon the erga omnes claim, and really you're putting it all on the specially affected basis, are you not?
No, Your Excellencies. The obligation erga omnes arises when there is pollution on the high seas. That means that any state in the world can have standing before this court and can claim for a restricted number of reparation under Article 48 of the ILC draft articles. However, for a state to be able to claim as an injured state, to claim for compensation, it has to be a specially affected state which has suffered a distinguishable injury that can be separated from the rest of the international community.
Thank you. Thank you very much for
May
your
please,
submission.
this Honourable Court.
Mr. Luke, will you be doing the rebuttal? Please address the court.
Two points of rebuttal, Your Excellencies. The first is with respect to the attribution of Thomas Good's conduct. The basis of the respondents' arguments was essentially that outrageous conduct done for private gain could not be attributed to the state. However, if this was the case, cases such as Humans and Care would have been decided fundamentally differently. In particular, they have attempted to argue that acts that are manifestly outside the scope of someone's functions should not be attributed. However, this exact proposal was addressed by the International Law Commission in its 1975 report to the General Assembly, and it was stated that if such a rule was applied, it would provide an easy loophole in particularly serious cases where a state's international responsibility ought to be affirmed. The Humans case has showed us this, where joining a rioting mob was held to be attributable to the state, acts which are clearly beyond the competence of the state, of that organ, so to speak. This case is fundamentally similar in that, like the soldiers in the Humans claims, Thomas Good was on duty, he was acting under the general command of the Navy, and he was acting as an agent of the state. He used his apparent authority and means placed at his disposal to gain access to the vessel, and if the respondent is able to contend that the activities of the troops in the Humans case was in fact merely an extension of their normal functions in joining a rioting mob, then it is similarly an extension of a pilot's normal functions in taking excessive control of the vessel in this case. Secondly, with respect to Apollonia's alleged breach of its duties with respect to the transportation of MOCs, the respondent argued that Apollonia is in its rights of passage and is liable for the damage to the shallows. However, these submissions were contingent upon the existence of a customary duty to notify other states of the transportation of nuclear materials. However, there is no such right at customary international law. With respect to state practice, it was proposed by Fiji in the negotiation of the Law of the Sea Convention and rejected. It was raised in 1996 before the International Maritime Organization and was rejected. It was again raised at the International Atomic Energy Agency Joint Convention on Spent Fuel Management and rejected in 1997, and was raised and rejected at the 45th General Convention of the International Atomic Energy Agency in 2001. Moreover, the support for the existence of such a right from countries such as New Zealand does not evidence opinio juris, as New Zealand has described it as an evolutionary development and has thanked states for their compliance with what is, in their description, a non-binding obligation. So there is no opinio juris and there is no sufficient state practice to establish such a custom, and Apollonia has therefore not breached its obligations.
Mr. Luke, if you transported mocks into a harbour of the respondent state, would you be required to tell them?
Yes, Your Excellency.
What's the difference between archipelagic waters and a harbour?
The freedom of the not of the high seas, but the freedom of innocent passage and archipelagic sea lane passage, Your Excellency.
So you say that archipelagic sea lane passage is what makes the difference?
No, Your Excellency, innocent passage also. The maritime states have consistently stated that it would be a breach of the Law of the Sea Conventions, innocent passage regimes and archipelagic sea lane regimes to require notification. And indeed, Article 23 of the Law of the Sea Convention, with respect to innocent passage, specifically envisages the transportation of hazardous materials and makes no reference to notification.
Thank you very much.
Thank you, Your Excellency.
Will it be Ms. Alias who will do the rebuttal?
It's Hamid, I think.
Your team. So Ms. Hamid is coming back to talk to us again.
Madam President, Your Excellencies, I have 2 quick points to make. Firstly, with regard to the customary nature of the duty to give prior notification, we would like to prove again that there is a custom to give prior notification by referring to the 2 regional customs of Mediterranean nations and Association of Caribbean States, and also the more than 100 national legislations which does impose the duty to give prior notification for nuclear ships transporting nuclear materials through the waters. Even if this Honourable Court does not agree that there is no customary duty to give prior notification, we would like to prove that under the circumstances before this Honourable Court, in this case, there is such duty. This is by virtue of Article 39, Paragraph 2, Paragraph 1 of the United Nations Convention on Law of the Sea, which states that states, while exercising right of sea lane passage, would have to comply with generally accepted international regulations with regard to the prevention of pollution from ships. And as had been shown before this Honourable Court, the precautionary measures or the precautionary principle thus is included under this international regulation for prevention of pollution. And since in this case, according to the factual metrics of this case, the MOX was shipped by only using a private carriers and without any naval escort vessels and without any armed guards on board of the ship, and it was only manned by a small crew through waters known to be frequented by pirates. This would pose a significant risk of harm to the coastal state. Therefore, Your Excellencies, there is a duty to give prior notification under the precautionary principles in this very case only. With regard to the attribution of the act of Mr. Thomas Good, the agent of Apollonia referred to the human's claim. In that case, the attributability is because there was no supervision, because there was supervision of superiors over the soldiers when they opened fire to the American nationals that they were supposed to protect from the rioters. And furthermore, Your Excellencies, the act in question was just an extension of their apparent authority. The apparent authority of a soldier does include the power to open fire, and in this case, to open fire is towards the person which is seek to protect instead of towards the rioters. Is just an extension of the apparent authority. In this case, Your Excellencies, the act of Mr. Thomas Good was piratical act, and piracy, under the definition of the United Nations Convention on Law of the Sea, it must be done for private ends. And furthermore, in this case, when an act is done for private ends, therefore it cannot be attributable to the state. And if we refer to the compromise itself, it states that it is apparent, Your Excellencies, may I just finish?
Just finish your sentence, yes.
Your Excellencies, it is apparent that when, if I may quote, he threatened to detonate the device if the captain and the crew did not surrender control of the ship. Aware the Raglannian pirates did not generally harm their victims, and in order to minimize the loss of life, the captain agreed. It is apparent to the captain that he was acting as a private pirate and not as an agent of Raglan when he threatened to detonate his explosive device.
Thank you very much.
May it please this honorable court.
The court will now rise and deliberate and will resume the session in due course. Please be seated. The tribunal wants to begin by saying that it's very much appreciated everything it's heard this afternoon. We know the teams have had a very long road to come here, that it's not just been today, but everything that has gone before for not only, again, the oralists we've heard, but those who've supported them and their coaches and all the many people involved in getting you to where you've been today. We're also aware that you had to select key arguments to put to us because of constraints of time, but we realize both from the memorials and the very nature of the case and from what we've heard come through, even lightly in your arguments today, that you have clearly done enormous amounts of work on also many other areas you weren't fully able to deploy before us today. You can, in fact, all feel very proud of yourselves. Now, I'm going to start with the individual presentation for the best oralist, and then I will tell you the court's views on the team winner. Again, we felt all of you did very well. A credit to your teams. Mr. Kolditz performed in a solid and professional manner, an impressive performance. Mr. Luke, we found particularly good on rebuttal. That was very well handled. Miss Alias, we admired the way you dealt with the difficult situation of so much being thrown at you and came back and gave us more good analysis. But overall, we feel that Ms. Hamid must get the Individualist Award. I would like to say we were impressed by her ability to handle the barrage of questions, marshal arguments very rapidly in response, and while doing so, bring in new elements that she had not previously deployed, and that showed a considerable advocacy skills. We now turn to the team winner, and we felt really that, as I've said, you all did well on the component elements we were told to look out for: style, poise, courtesy of demeanor, and of course knowing your stuff. Both sides analyzed the limited relevance of piracy very well. Taken overall, looking at the depth of legal argument and the ability to show knowledge of a great range of law, coupled with style and advocacy, we find the team winner, the applicants. Take this opportunity to say to all of you that these selections were not made out of any desire to give something to each side in a close-fought final. Good though you both were, these results were exactly as the bench saw the two selections, and furthermore it might give you all satisfaction to know that both as to the individual oralist and the team winner, the bench was unanimous. Well done, everyone.